Hi, everyone. I wanted to take a second to talk to you about the concept of trusts. The concept of trusts are complex and can be confusing to understand, and deciding when and how to use them in an estate plan can be complicated as well. This is because there are so many different types of trusts and they have unique purposes and unique fits for everyone and everyone's assets. Most of our estate plans will include one or more trusts. That doesn't necessarily mean that those trusts are freestanding individual documents. Sometimes we build those trusts or subtrusts into the term of an already existing trust or into the terms of a last will and testament. The concept of a trust is that you create a document that includes provisions for management of assets, and you allow someone else, a trustee, to manage those assets on behalf of the beneficiary. I think what gets more confusing is that some of those trusts, like a revocable living trust, include the same person wearing many different hats. So you might have the original estate planner or individual who wants to create a trust, and that person is called the testator. They might create a trust that allows them to be trustee, in which case the same individual would be wearing the testator hat and the trustee hat. Even more confusing is that some revocable living trusts, or many revocable living trusts, also include that testator, that trustee, that same individual who is now wearing two hats as the beneficiary of the trust. And that means that that person is now wearing three hats. So the key persons in a trust and the key language or terminology to understand is that the testator or the settlor is the person that has created the trust and likely funded it with their assets. The trustee is the person who is managing those assets, and that person is managing them on behalf of the beneficiary or beneficiaries. And those are the three key roles of a trust document. Now, the document itself is sort of an entity that we create. And I often tell clients to think of it like a vase. It's a vase that is empty until we fill it with flowers, and those flowers are our assets. And the mere creation of the vase does not mean that it applies to all, or in fact, any of our assets, unless we have funded those trusts with flowers or our assets. And we do that by retitling those assets into the name of the trust. So sometimes I'll get a call from a potential client who will say, I went to the bank and I tried to open a trust account, and the bank told me I needed a lawyer. Can you contact the bank now that I've hired you and ask them to open the trust account? And the reason that the bank told the individual that they need a lawyer is not because we have any special pull or power with the banks, but because we need to create the trust document, which will then have the account titled in the name of it. So the account will be titled in the name of the trust document, but the trust document itself will provide the provisions for how that account should be managed and who it should be managed for. The concept of trust can be complicated to understand, but I assure all of my potential clients and all of my current clients that we talk through the concept of trust in many of our estate planning meetings. And if any of you have any questions, please don't hesitate to reach out and we can discuss either the trust in your current plan or incorporating trust in a new estate plan.